The OMA traditional design database started from what we now call cultural misappropriation case, where the designs of the OMA were replicated by a fashion company and sold without any involvement of the OMA community. So what makes the Cultural Intellectual Property Rights Initiative particular is that we work holistically on developing a system that nurtures, sustains, and protects traditional knowledge and traditional cultural expression. So we don't talk only about intellectual property rights that apply to the craft ecosystem. We are looking at sui generis protection forms. So forms that we can design specifically for the sector and that are not necessarily based on the concept of property, on the concept of ownership. We look at cultural intellectual property rights as human rights. It's about the identity and the life, the cultural continuity of peoples. We work with indigenous groups, ethnic groups, and local communities around the world. We're looking at all the tensions between the different systems and the quite different approaches. And what we came up with is a contractual framework that we hope will transform into a policy proposal, and that is called the 3Cs rule. And the 3Cs rule refers to consent, and that is the free, prior, and informed consent of the community, the group, or the individual that we call a custodian of traditional knowledge and traditional cultural expression. So we don't use the word owner because the legal concept that we base this work on is that of custodianship. We work on implementing this framework in different contractual relationships. It's also the framework on which we created the legal strategy for the OMA traditional textile design database. This tool is indeed helping to address all the tensions and the difficulties to always have access to the international law or even to legal support. In the case of the OMA traditional textile design database, their designs were copied by a fashion company in Italy. And the Traditional Arts and Ethnology Center in Laos has supported the OMA, having worked with them for over a decade to bring this attention to the public. So they created a social media campaign. According to the law in Europe, what the European fashion company Max Mara did was not breaking the law. So then we had to be very careful to how do we address what we know is right with what the law says. The idea was then to create a legal strategy that is based on documentation of traditional cultural expression. And the goal was to help the Homa community to communicate that they are the custodians of this knowledge. A very important step was free, prior, and informed consent. It's very important that the community is fully aware of the implications of the legal strategy that they will be adopting. And it was very important for us to ensure that the community has still control over their traditional knowledge and traditional cultural expressions, so that this database is not placed or made public, and then we open up the risk of further misappropriation. And whenever we talk about legal strategy, I think it's very important that we form groups of complementary expertise and definitely look into talking to experts and also cross-interdisciplinary experts, because we are talking also a lot in this group of experts about the risks associated to IP protection. And this is where we are also exploring these new or different forms of relationship with the knowledge.